The right to die with dignity, it's a fundamental right, and that should be granted as per the prescribed guidelines to terminally ill patients. The Supreme Court, or SC for short, has recognized this right, and it's passed a judgment in 2023 modifying those guidelines. To help terminally ill patients, the right to die with dignity is now more accessible. Hello, this is Jerry and this is your host, and welcome to my video where we are going to explain a recent judgment on euthanasia and the right to die with dignity in a simple and understandable way. The case law that we are going to discuss is Common Cause versus Union of India. It's where a 5-member bench of the Supreme Court passed a judgment after looking at all aspects related to euthanasia and advance directive. So this is a summary of what we're going to discuss in this video. First, what is the meaning of advance directive? 2. What is the background of this case and how it got instituted? This involves a bit of explanation of Article 21. 3. Issues faced by the court in 2018. 4. Points discussed during the argument. And 5th, what is the final judgment ordered? And finally, what are the changes to the advance directive? So, let's quit the talking and let's dive into the discussion. So, you would ask the question, what is advance directives? Advance directives is a document written by a person who is going to die, and it's a detailed end of life instruction to be followed when a person is incapable of expressing his decisions, or when he's a patient on his deathbed or in a vegetable state. So, this judgment passed by a 5-member bench on 24th January 2023. It's really important and it modifies the advance directive guidelines. The judgment stops any loophole that is existent in previous judgments to make guidelines more accessible to all people, especially terminally ill people. So, let's explain the background of this case. An NGO called Common Cause. As mentioned, it's an NGO that files cases or on issues that affect public life. And one such case fought is the right to have a dignified death. And the story began in 2002. They wrote to the Ministry of Law and Justice, Health and Family Welfare and Company Affairs, disclosing the opening or the ethical aspects of death in a country called India. They filed a writ, and the main argument is that a terminally ill patient should have the right and should inform his decisions to end his or her own life, and that too without interference from others. And they argue that a hospital placing that person on a life support does more harm than good. Such persons has a right to control their body, the privacy, and ultimately the right to die with dignity. And this right is protected under Article 21 of the Constitution. So, what is Article 21? It's the right to life and personal liberty. Let's discuss what are the issues faced by the court in 2018. In 2018, the judgment was passed, and the main highlight is, first, whether a person can die or the right to die is included in the Constitution. The right guarantees the right to life and liberty. 2. Euthanasia. It's otherwise called as mercy killing. Can it be legalized by the legislation? So, let's ask the question, what is legislation? It means the government passing a law. Third, what is the difference between active and passive euthanasia? And will this affect the court's decision in permitting or stopping end-of-life actions? This decision, in fact, can be made only based on legal and moral principles. So, you might ask the question, what is active and passive euthanasia? Active euthanasia is deliberately taking away a person's life, and that too by giving a lethal dose of medication. So these are for criminals. And passive euthanasia is withdrawing life-supporting treatment and allow that person to die naturally. So the question would come was, what are the points discussed during the argument? Firstly, the right to refuse treatment. It was a primary argument where an individual is free to make his own choice. Everyone has the right to this. This means a person can say no to certain treatments, but others think it might be necessary. Second, passive euthanasia. This is the broader context of Article 21, and it was argued that laws should adapt to the changing needs of society. They also argued that the concept of dignity forms a part of the larger concept such as the right to life and personal freedom. This was actually mentioned in Article 21. In fact, dignity cannot be taken away by any law because it is natural law. So there is no law to substantiate right to dignity. Third, a right to self-determination. People should make their own choice about their bodies without any interference from others. But such choice is to be given to the individual whether he or she should end their own life. However, there's another catch. The thought process is the court may not understand a person's state of mind. Sometimes it might be the person's culture, religion, and it might influence a person's decision to take that extreme step. I'll come with an example in a few seconds from now. So, the court might be looking at an individual right, but it might be missing the bigger picture about such decisions of euthanasia and suicide. Now, the fourth, the court should take into account social morality, medical ethicality, and state interest. And these are different concerns the court faced while passing the judgment regarding euthanasia. Also, whether society will view this as morally correct or not. So the court's decision was to legalize passive euthanasia, and that was the only solution. But legalizing this form of euthanasia, would it change society's perception? Okay, it was further argued that the court should focus on dignity, as some people might see suffering as good from a religious perspective. For example, Christianity views suffering as good. So finally, the arguments was by the state and the intervener about the idea of dying with dignity, and it forms part of Article 21, and this should not be rejected because few people might misuse it. They informed the court that individual interest is more important than the interest of the state. This is because the laws are connected with society. Finally, the decision was passed by the Supreme Court, and it is important judgment for euthanasia as it is a choice of an individual, us, and not the state choice. Finally, the judgment was passed on 24th January 2023, and it was a judgment that was passed by 5-judge bench. It was led by Justice K.M. Joseph, and it was an important judgment altering the guidelines where terminally ill patients can withdraw from treatment, thus helping them in the support of passive euthanasia. The benefit of this judgment was to reduce the suffering of terminally ill patients who are unable to communicate their wish. The change in rules also applies to cases where patients have already given instructions beforehand. Otherwise let's call it as advanced medical directives, or in cases where there is no instructions given by the patients. So you might ask, what are the guidelines or the changes in the guidelines? Previously, if the Advanced Medical Directive, let's call it in short for AMD, a request was made by the patient and it was confirmed by the doctor treating the patient that he cannot be cured. So the hospital, what they would do is they would form a medical board with 3 experts who is having experience of more than 20 years. Now the medical board certifies and AMD can be carried out. Then the district collector is informed. who will form a second medical board, which includes the chief medical officer of that district. Once the second medical board certifies, only then the act will be carried out. So, what are the current changes passed after the judgment? People with 5 years of experience can now join the boards. The chief medical officer of that district can nominate another person in his place. The minimum number of board members from 5 is reduced to 3. Now both the boards have to pass the decision in 48 hours. Now the second recent change is drastically it reduced the involvement of a judicial magistrate. Presently, because of the judgment, the AMD needs to be signed by 2 witnesses before the gazetted officer, as there is no requirement to go and stand in front of the magistrate for a signature. The duty of informing the family currently is with the person who executes the AMD, the person who gives that injection or removes the white life support, or the person or the patient informs the family directly. The judicial magistrate is involved only if the boards agree to stop the treatment. The AMD will be executed, and only after the family members agree. Well, let's conclude this video, and I hope this video has helped you understand laws around euthanasia. This landmark judgment has helped to streamline the entire process of fulfilling one's wish, that is to die with dignity. This judgment is a win for terminally ill patients who do not need to suffer, because at the end of it, everyone needs a dignified death. Well, if you like this video, do post your comments and also hit the like button. This would give the added encouragement for me to bring better videos and help to explain case laws in a better manner. Also, don't forget to subscribe to my channel, and let me conclude in the words of the Chief Justice of India, who is also the part of the 5-member bench who passed the judgment, Mr. Justice Deepak Mishra. He said that my last remarks are a pious hope that the legislature would step in at the earliest and enact a comprehensive law on living will and advance directive, so that there is a proper statutory regime to govern various aspects and nuances thereof, which would take care of the apprehensions that are expressed against euthanasia. Take care and see you in the next video. Bye-bye.